Hi, everyone. Harry here to talk about the skirmish, the first skirmish in Judge Chutkin's court in the 1-6 indictment between Trump and the DOJ and Jack Smith. Now, the first big point to note, there's a way of looking at this that makes it seem like small beer. There's not that big divide between their bottom line positions of what they would do with this, etc. But it isn't. The real thing to bring home here is how this is Trump trying to set the stage and draw a line to just act improperly throughout the trial. So to set it up, because a lot of this is just Trump has tried to say, oh, it's his First Amendment rights that are being abridged, and it is total garbage. So the deal is when someone's indicted, there are federal rules. The Constitution doesn't require, and some countries don't do it, the prosecution to turn over information, but out of fairness and as part of a whole big system that you do to provide for a trial that's fair to defendants and embeds confidence in the people, you give them certain information. And up front, you give them like their own statements and different exhibits and stuff. But the DOJ in the Mar-a-Lago case gave them much, much more, and they're prepared to do that here. So what they're saying is, here you go. Here is close to the motherlode of everything we've done and everything we've developed. Have at it. Oh, by the way, please remember to treat this as you do. This is the second point. It's not, it's no the First Amendment is a total red herring. And the second point is it is routine in criminal cases that defendants get, this advantage of having, recourse to this information so they can plan their defense, but not so they can go and selectively try their case in the press, which, notice, is something the DOJ cannot do. It has to wait till trial. So it would be deeply unfair for the defense to be able to take this information and generally try their case in the press. Why might Trump want to? And this is the sort of third point to emphasize. 3 reasons, and all of them are no good. One, of course, is just delay. They come up with something that would get things, started right away. Here's all this information. And, Trump wants 2 weeks before they'll even have a hearing about it and the like. Now, the judge hasn't stood still for that, with a order that has a little bit of a flavor of, okay, children, come to me now. She's agreed to a hearing, but very quickly. It'll be by Friday. That would be one reason. What would be the other reason? In order to propound his totally bogus view of the case to the American people in the that this is what he's calling his First Amendment rights in the campaign, which is to say, of course, there are 2 big reasons you're not supposed to go and take this information and use it, especially selectively in the public sphere. One is you'll pollute the jury pool. You want people coming in who don't have either side's version of the case, are just ready to hear the evidence in the, proper way that evidence is set up. And we really go to great, great lengths to make it, available, as if anyone's ever been in a trial in a certain way that is considered, among other things, again, the most fair to defendants. And then the third reason, and maybe the biggest concern for the DOJ, is witness intimidation. You know who the witnesses are, and you can really intimidate them. And let me just take one step back. You can call this the fourth point. Zero doubt. Here's an example in which Trump is not your normal defendant and gets a break. Anyone in another case who tweets out something like, if you come for me, I'm coming for you, is going right into jail. Do not pass go, do not collect $200. That would, he's out now on conditions. He has been released by the court pending trial with pretty light conditions. But they could just yank those conditions and say, now you go into, you're incarcerated until trial. Why? Because we can't be certain otherwise that you won't intimidate witnesses or pollute the jury pool. And that's the final kind of club that Chutkin is holding after a gag order and other things. It's putting him in jail. Now, she's got to be super cautious about this and knows it. He's running a campaign. It's not just his First Amendment rights, but First Amendment or some broad democratic rights of the people that would be abridged if he is, thrown into jail. But her lookout now is she's the person who has to think about a unpolluted jury pool, has to think about witnesses not endangered for doing their duty or not threatened or intimidated. And that's Trump's entire playbook. So he is really in a chicken game with Judge Chutkin. Okay, so they go back and forth and back and forth and back and forth. And she finally says, okay, I'll have a get together and 2 dates that you can make it. Trump doesn't have to be there. I will hold a hearing on Friday, August 11th, this Friday. So it's going to be pretty telling. To my mind, I think she's going to be rough on the Trump side because what the DOJ is proposing, after all, is routine in all kinds of cases. And there's no First Amendment right, even for a candidate for president of the United States, to reveal evidence and selectively give his, she's got to worry, Judge Chutkin first, about his polluting the jury pool and threatening witnesses. So she might try to stitch together something that gets in a more tailored way at that. But certainly the easiest is just to say, talk about your campaign, say whatever you want about why you think the prosecution is an attack on you and the deep state and all your voters, etc. But you may not use this information you're being given it for one reason only, to prepare your case in chief. It's a good thing for you that you're getting it. They want to give it to you sooner rather than later so you can have at it. But, don't think that you can now just try the case in the public, in the court of public opinion, or that you can threaten anyone, as he patently did with Pence, right? The way he insulted Pence is just an invitation to one of his crazy followers to attack him or whatever. It's a fraught trial. It's super important that it be done fairly, but he is basically on trial for setting forces in motion that he didn't give a shit about where they would end up. And people were killed. So something like that happens here. He wouldn't care. He would probably revel in it. And B, it's a disaster for the country. So that has to be Chutkin's lookout. Anyway, so she summoned them. She's giving them the hearing, but I think she will, especially given some of the things that Trump has said, she has to be careful because she only has so many cards to play before all that's left is putting him in jail. And nobody wants, Chutkin in particular, to put him in the candidate for the Republican nomination in jail. In some ways, it plays into his martyrdom hands. But, this is just flagrantly inappropriate what he's trying to do. So be a very interesting hearing. It's in a sense kind of indulgent to them that she's holding it because they've asked for it. But I think she will be pretty firm and she will not permit him to do what he's asking. That is to, in exercise of his First Amendment rights, which he doesn't have here. If he did, all 300 of the defendants who operated under parallel kinds of protective orders in the whole side of the case involving the marauders on the ground would also have First Amendment rights. So that just can't be. And I think she'll make that clear. He won't be happy with the results, but you'll also see her straining to, she doesn't want to be coming out of the box and looking as if she is biased, etc. So there you have it. It'll be, for that reason, even I'll end where I started, which is they may not be that far apart. It doesn't seem all that huge, and yet it really sets a tone for what's going to be happening over the next, many, many months. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.